For the east of the state of Kansas is known.
Please be seated. Good morning, everyone. Wonderful to have everyone with us today. Welcome to the September 2022 Kansas Court of Appeals docket. My name, of course, is Sarah Warner. I'm going to be presiding over proceedings today. Really, that just means that I'm a glorified timekeeper. And so if you see me looking at my phone, it's just because I am keeping track of the time. Before we call this morning's docket, I'd like to introduce the distinguished members of our panel, and boy, how distinguished they are. To my right, your left, you see Judge Henry Green, who is the longest serving member of our court since 1993, and he hails from Leavenworth. And then to my left, your right, we have the junior member of our panel, Judge Stephen Hill, who is the longest serving law-trained judge in the state of Kansas. But he joined our court in 2004 after spending several years on the district court bench in Taylor. And of course, I'm Sarah Warner. I'm not the longest serving member of our court, but I joined in 2019, and I'm just thrilled to be able to be here with you today. In preparation for today's argument, we have thoroughly reviewed all of the briefs. We are familiar with the facts of the case, but this set of arguments is being streamed online. And so I would like to ask the appellant to spend about a minute, and it won't count against your time, but to spend about a minute talking about the background of the case and why we're here. That way people have some context if they're watching. Each of these cases is scheduled for 20 minutes of argument per side. If you're the appellant, be sure to ask for rebuttal if you'd like rebuttal, and we'll take that into consideration. All right, at this time, we can call the first case on this morning's docket, and that is case number 124475, Mineras Almeida et al. Versus Kansas State University. Would the parties please state their appearances?
Walsh on behalf of the students, talents in both the Mineras Almeida
Thank you.
Your Honor, Tony Rupp and Daniel Buller appear on behalf of the appellee, Kansas State University.
Thank you very much. Ms. Walsh. Would you like any time for rebuttal?
If I may, I'd like to reserve 7 minutes.
10 minutes are granted. You may begin.
May it please the court, Your Honors, asked for a brief description of the case. I guess I will begin by saying, if everything always went just as we expected it to, we wouldn't have very many contract disputes. But as we know, things don't always go as expected. And certainly at the beginning of 2020, we could have known that 3 months in, our country would be shut down due to a global pandemic, that Kansas State University and universities across the nation in the second half of the semester would close their campuses and send students home and move completely to remote instruction. In this case, the students are not questioning the university's decision to shut down. The students are questioning the university's decision not to provide any measure of refunds for campus-based services that were expected, that were paid for, but that Kansas State University was unable to provide. In contract law and its equitable alternatives, provide a remedy for which plaintiffs have stated a claim. We are asking this court to reverse the district court's dismissal of the consolidated fee and tuition cases for 3 reasons, over which this court has de novo review. First, these are breach of contract claims, not improper claims for educational malpractice. Second, the breach of contract claims are or can be sufficiently pled. It is for a fact finder to determine what the parties intended when K-State agreed to provide educational services in exchange for payment of tuition and fees. Third, the alternatively pled claims that sound in implied contract for unjust enrichment and in the fee case for money had and received are not barred for plaintiff's failure to have first submitted them to the Joint Committee on Special Claims for the state. And then finally, we would ask that the court address whether the district court abused its discretion in denying plaintiff's motion for leave to amend and file a consolidated amended complaint. So I would first address that the breach of contract claims here are not educational malpractice claims. It's hard to see how the specter of educational malpractice would even arise in the fee case. You know, these are really line item charges for campus services that just weren't provided. The campus was closed. And the services were, the mandatory student fee was literally called a campus privilege fee. But in the tuition case, the district court focused on a few words pulled from the allegations that describe the online instruction second half of the semester as subpar, as having diminished value, of having educational leniency.
Counsel, in the tuition case, what are the damages that are claimed?
So this is a great question, and I think this is where the district court, perhaps, and the defendants conflate the issue of the liability inquiry with the damages inquiry. You know, the jury in this case will be tasked with determining exactly what that value is. What value did the plaintiffs not receive in their second half of the semester? But that doesn't render this a situation where the court is making value judgments or second guessing the university's decisions on curriculum or methods or any of the things that are a typical educational malpractice tort claim.
And how is that? Because I can understand that your argument is that this was a part of the contract and we have to determine the damages. But it seems like that damages assessment inherently requires some kind of a value assessment about the quality of the education that was provided.
It may, and I think that juries are tasked with making those kind of determinations in almost every civil case. And sometimes those determinations are harder or messier than in other cases.
But haven't we decided as a policy matter that that's not an area we don't want juries or judges assessing the quality of education kind of as a Monday morning quarterback?
I would, no, that's right. And in Finstead, the court, you know, said educational malpractice claims are not recognized in Kansas. But with that said, I think the way that we are thinking about these claims as breach of contract claims, even on the tuition side, is that the parties, the plaintiffs, didn't get what they paid for. You know, they had an agreement that they understood to involve these certain things, and they didn't get those certain things for the full semester. And it will be the jury's job to determine what their damage is in monetarily. And the inquiry, really why this claim isn't educational malpractice is because the inquiry is objective. It's not subjective. We're asking, was there an agreement? What was the agreement? Did the defendants breach the agreement? And what were plaintiff's damages? And to what extent were plaintiffs damaged? I hope that I've answered your question.
I think so. Can I ask one more question about the
Absolutely.
contracts that you're discussing right now? What is the nature of the contract? Is it an implied contract? Is it an express contract with some unclear terms? What is it?
So this is going to kind of move us into why I believe the contract claim is sufficiently pled or can be sufficiently pled. I think when we initially brought the case, we conceived of it a certain way. We described all these materials and the reference to the comprehensive tuition and fee structure that set out what all the charges were for. It distinguished between students enrolling in online courses versus students enrolling in traditional on-campus courses. It set out line items for what their fees were intended to cover. And I think that you can think about these claims as either express or implied. At this point, I think now that we're on appeal and the defendant offered the financial responsibility agreement, which was not something that plaintiffs had and was not attached to the petitions, but it came in from defendants in support of the motion to dismiss the tuition case, and actually at the reply point in the fee case. Even if we accept the defendant's position that the financial responsibility agreement, I'll just call it FRA, is the exclusive agreement, express, specific, written contract between the parties, it's still for the fact finder to determine what the parties reasonably intended when K-State agreed to provide educational services, which is what the FRA refers to.
So is your answer to the judge's question, is it an express contract or is it an implied contract?
I think that on appeal, we are willing to say that there is an express contract, that the FRA, as defendants argue, is the express contract here.
Does that mean then that you would be barred because you did not submit a claim to the Joint Committee on Special Claims?
No, I don't believe so. And I can address why, if you'd like me to.
If I asked the question, hoping that you would answer it.
Yes, so on the jurisdictional issue, which is how it's framed, the argument is that the two statutes, and we set them out in the briefing, I think. I'm not going to recite them, but they're on page 34 of our opening brief. To quote Justice Kagan, we are all textualists now. So looking at the text of these statutes, they require submission to the JCSC, the Joint Committee, only for certain judgments or claims that are payable from the state treasury. They do not, by their text, require submission as a precondition to filing a civil action.
Counsel, even if we agree with you, our hands are kind of tied on that point, aren't they, by the Kansas Supreme Court's decisions?
We concede that you are duty bound to follow on point Supreme Court precedent. I would suggest that you are also duty bound to follow the statute that governs here. And if you were willing to consider distinguishing this case from the Wheat Sharp cases, I would offer some ideas on that.
Is that necessary if this is an express contract?
No, it's not. And the beauty of law in Kansas on remedies election is that the plaintiff can plead both, in the alternative, and that it can even go to the jury on both. We only get one satisfaction, but I don't think that, I do think these issues all need to be addressed in the appeal. But no, I think you're exactly right. If there's an express contract, then we can present that claim to the jury. But let me suggest, going back to your initial question about the wheat case, I would say, and I know we've covered this in the briefing, but the Supreme Court didn't address the statutes directly. The primary focus of that case was a statute that was since repealed, that specifically said, referred to tort and contract claims. And the court, in addressing the implied contract claims and referring to the two statutes at issue here, it noted that the statute imposes a condition precedent to disbursement of funds from the state treasury. And that is accurate. That's what the statutes say. But the court then went on to hold, and in our view, it's contrary to the statutory language, that filing and processing are held to be conditions precedent to the maintenance of an action. Ultimately, however, the court resolved the issue by holding that in the case at bar, no attempt was made to comply with the statutes. Well, in our case, we haven't failed to comply with the statutes. As we read the statutes, if we obtain a judgment based on the implied contract theory on unjust enrichment, we then have a collection issue. We submit the judgment to the joint committee before it could be paid out of the state treasury. But before we even get to that, the fact is we're here on a motion to dismiss, and there are fact questions about the source of funds that prevent dismissal in the first place. The
I
plaintiff.
just wanted to let you know that you're down to about a minute left of your opening time.
Okay, I appreciate, thank you. The source of funds is a fact question that can't be resolved. And I had a few points to discuss on source of funds if you had any questions. I think I will go back though to some of the initial questions on the breach of contract claim, because I just wanted to point out that the FRA is silent on what educational services are. They are not described. Plaintiffs allege it includes, on-campus experience related to instruction and access to facilities. Kansas State suggests that it relates maybe only to course credit or just the privilege of registering. But it is fundamental in Kansas. The primary rule for interpreting written contracts is to ascertain the party's intent. If the terms of the contract are clear, you determine the intent of the parties from the language of the contract. But if the written contract's language is ambiguous or unclear, then extrinsic or parole evidence may be considered to construe it. And I'm quoting from Waste Connections, a Kansas Supreme Court case from 2013. And we also submitted a 609 letter on the Baylor case. It was right on point with that. I think I'll wrap up because my time is up. Thank you.
Okay, thank you. You have 7 minutes remaining for thank you. Mr. Rep, you have 20 minutes.
Thank you. If I could get a 5-minute warning, I'd sure appreciate it.
Absolutely.
Thank you. It's my honor to represent Kansas State University here today in these consolidated cases brought by 4 students who continued to take classes remotely from the same faculty, received course credit, and graduated from K-State University in the spring semester of 2020. These are among hundreds of cases nationally and one of several thus far in Kansas. Certainly more are possible against every state university and every community college and every institution of higher learning in the state of Kansas based on these theories. Accordingly, the decisions the court makes here will have impact on potentially large numbers of claims and potential claims. We are here today because the district court properly applied the law of the state of Kansas and dismissed the claims against Kansas State University. We ask this court to affirm the district court's opinion. What the district court did is it reviewed the two petitions. It reviewed the binding precedent of the Kansas Supreme Court. It reviewed the Kansas statutes, and it concluded accurately that plaintiffs have not stated a claim. Let's take a look at the two petitions. The tuition case is the Plank case. The only reference to a contract is in paragraph 2, which says in the most conclusory of terms that the parties entered into a contract whereby the plaintiffs would provide payment in the form of tuition and the defendants would provide in-person educational services. It doesn't say whether the contract was express or implied. It doesn't say whether the contract was oral or in writing. It doesn't identify the date of the contract or who entered it on behalf of K-State.
Counsel, is that necessary for notice pleading?
It is, because Kansas law is pretty clear, I think, that conclusory allegations are not sufficient, that in a breach of contract case, you need to identify the contract and the specific provisions of it that are breached. And I don't believe that that there is anywhere near that in this situation.
Is it Kansas State's position that there is no contract between the students and the university?
Kansas State has identified that there is the financial responsibility agreement, which, by the way, is never pleaded by the plaintiffs, and they don't argue in their briefing on this appeal that the financial responsibility agreement is an express contract. That express contract says in it that this is a promissory note. It supersedes all other contracts or promises, and that at the time that the student registers for classes, that person becomes responsible for tuition and fees. And we believe that that is the contract. So yes, the defendants do believe that there is a contract that was not pleaded by the plaintiff and that has not been breached by the defendant. There's no argument before the district court, no preservation of an issue that the FRA constitutes an express contract and it was somehow breached. The contract.
What do assuming that's correct, that is a contract, an express contract, what do the students get from that? They sign it, and what do they get in exchange?
Well, they get the opportunity to take classes at Kansas State University, earn a degree from Kansas State University, gather all the benefits of being a student at Kansas State University that are offered at that particular moment.
And then the doors got shut.
Well, the door, sometimes the door shut. I mean, sometimes you go to K-State and they offer a class in microbiology in the second hour on the third day. And sometimes that
We're not talking about, I don't think we're talking about one solitary class. The doors got shut.
The doors got shut here and everywhere else.
Yeah, and the doors got shut and they said, well, we'll talk to you on the TV.
And where is the contract I would submit that says we will not shut the doors or that we will provide a refund if we do shut the doors? And that hasn't been identified. There is no such thing. And so what they are asking the court to do, Your Honor, is to rewrite a contract and to write a contract that is that is certainly not an express contract of Kansas State University, that we will provide a refund in the event of a worldwide pandemic. That's certainly not alleged anywhere. What they are arguing is that the court should somehow rewrite the contract And I would submit that's an implied
Let's look
contract.
at that contract. The financial responsibility agreement that you admitted as a contract says that the students will pay tuition and fees in exchange for quote services. What services?
The services that are provided are the educational services that Kansas State provides at any particular
And
time.
how do we know that from the written language of that financial
It
responsibility?
uses the words educational services,
It also just uses the word services though, right?
educational services.
And what are those?
Well, those would be the educational services that are provided by Kansas State University at any point in time.
And
So at the time, I mean, and Kansas State certainly did, as noted here and acknowledged in the petitions of the plaintiffs. They graduated in the
does it
spring
say-
of
does the financial
2020.
responsibility agreement say that you will get whatever services happen to be offered at the time, or is it just say services? I mean, how would a student know what those services are?
The student would have an understanding of the services based on I guess what I would say is that they're going for an education with an opportunity to get a degree and take classes from faculty, which is exactly what occurred at Kansas State University, and Kansas State stepped up. There was no financial detriment to any of these students from it. The CARES Act and other things stepped in to take care of students who needed the assistance. And
What about the students who decided, and I'm thinking now of the fee plaintiffs, the students who decided to be on campus for whatever reason, they made that decision. And then along with that comes this responsibility, partially identified in the financial responsibility agreement. They have to pay fees, including things like a campus privilege fee. How is that? Does that change your assessment at all?
not whatsoever. And in fact, Your Honor, Kansas statute, and the court considered the Kansas statute here, and the Kansas statute is critical because it defines what those student fees are. And student fees are not access fees or usage fees by state statute under 76-719, and we've briefed this. Such fees are to be used for the purpose of supporting student activities. So even if you never use the bus, you still pay a fee for the usage of the bus.
What if the
because
bus
you're
doesn't
supporting.
run?
If the costs of having a bus system still continue. I think the bus did continue, but regardless, the fact is that under state statute, you're supporting the student activities, you're supporting these activities. It is not a fee to access the ball game or access the.
And does the financial responsibility agreement incorporate by reference the definition of fees within the statute?
Well, I don't know that the FRA goes on to define that as such, but the statute does, and Kansas State certainly wouldn't have the authority to enter into a financial responsibility agreement with a student that wasn't compliant with Kansas law, and Kansas statute does define what that's for.
Mr. Rupp, I want to shift gears if we could,
Absolutely.
because I'm concerned about when you sue the state of Kansas or any of its various forms,
Mhm.
there's always a different procedure that has to be involved. And I'm concerned about the Joint Committee on Special Claims and whether these claims that are being made in this lawsuit, or both lawsuits, actually should have been submitted to that body first as a condition precedent before filing a lawsuit. What's your position on that?
Our position is that the answer is absolutely yes, and that the fact that they did not submit these claims to the Joint Committee bars these claims as a matter of law, and that's what the court found. Let's start with and this applies to both the tuition and fees claims as pleaded by the plaintiffs in their petition because they did not plead an express contract. And all implied contract claims, whether they're denominated an implied contract claim or a money had and received claim, or an unjust enrichment claim as set forth here, are required by state law. Two statutes, both of which have been interpreted by the Kansas Supreme Court in Wheat and in Sharp, and are binding on this court, to require that the claim first be submitted to the joint committee. Beyond that, to make an argument that hey, we're just the plaintiffs, we don't know where the money is going to come from. Kansas law, and there's a long number of cases that say that a claim against the university is a claim against the state agency, is a claim against the state. And moreover, Kansas statutes are very specific that both tuition and fees are paid into the state treasury in an account controlled by the university itself. So by state law, a claim for a tuition refund or a claim for a fee refund is a claim against the state treasury and is subject to this.
Does that mean that every request for reimbursement has to go for anything from K-State has to go through the joint committee?
I don't believe that they would be required to go through the joint committee just to send a letter to the university asking for money back. But if they're going to sue the university, they would need to first file a claim before filing suit. It's a condition precedent to the lawsuit. It's not a condition precedent to asking. I mean, you can always write a letter or go through a process or contact the registrar and say, hey, I think individually I should be entitled to a recovery.
But before K-State would pay that reimbursement, would they have to go through the joint committee to get authorization?
I think K-State would have control over its own. K-State is a state agency that would have control over its own funds and could make that decision.
And where would that, do you have any idea where that, and I'm just asking because I'm trying to get my head around this, where that reimbursement would come from?
Well, it would, if they're asking for a refund of tuition or fees by state statute, that would come from the state treasury account controlled by Kansas State University.
But there are some instances you believe that you wouldn't have to go through this very formalized joint committee process in order to affect that kind of.
Could affect it, you just couldn't sue over it. It's not an obligation of Kansas State to pay the money. They could choose to pay the money, but if they didn't choose to pay the money and you thought that was wrongful, you would first have to file a claim with the joint committee or joint commission.
Would you agree that this the condition precedent that is in our Kansas Supreme Court case law, that's something that, for better or worse, the Kansas Supreme Court has kind of grafted onto that statute? That statute didn't specifically state it was a condition precedent.
I would submit as the following: under sovereign immunity, a claim against the state is only as broad as the legislature grants there to be a claim against the state. And I think from that perspective, the Supreme Court has accurately determined that it ought to be narrowed. Ought to be narrow, and has, I think, accurately interpreted both Wheat and Sharp.
Thank you. And at this point, you have about 5.5 minutes, but there's a natural pause.
Perfect. Thank you. I will try to get to at least one other issue, and that is we've heard several times today that these claims were or could have been pleaded appropriately. We really haven't heard how they were pleaded appropriately. We've now heard for the first time that a position of the plaintiffs that the financial responsibility agreement is an express contract, that's certainly not pleaded, certainly not preserved. So the question is, should the court have allowed the plaintiffs to go back and plead this? The plaintiffs never argued that we want to go back and plead this case as a claim under the financial responsibility agreement. That's not preserved. In fact, they did not ever attach to any brief or anywhere any copy of what they wanted to have this court or to have the district court consider to be the amended pleading. We have no idea what would have been in that amended pleading.
When I was looking at the court's decision here, and evidently they were impressed by one of the arguments that you made as far as supporting your motion to dismiss. And you argued that the express and implied contract cannot coexist at the pleading stage. Evidently, something was going on at the time for you to make that argument, right?
The reason we made that argument is in the event that the pleadings, that would be paragraph 2 of the tuition case, or I think really paragraph 3 of the fee case, in the event that those were deemed to be an express contract, then you can't have both in the same pleading.
And the trial court was impressed with this particular argument. But what bothers me, you know, if the trial court liked this particular argument, as the plaintiffs indicated today, at this particular stage, a motion to dismiss, you can make alternative arguments, right?
You can.
And we're supposed to look at those type of arguments and pleadings they make in their favor, right?
We are, however, we can't give credit to conclusory arguments, and if you're going to breach, if you're going to have a contract, it seems to me, and I think it's consistent with Kansas law, that you can't just simply say that somewhere there's an amorphous contract. You have to identify it. You have to say, these parties contracted here, and here's what was in that contract, and they don't do that.
Is that also the case with an implied in fact contract?
I think they don't get anywhere near an implied in fact contract, but we do have the benefit of the Wheat and Sharp decisions in the Kansas statutes that if this is an implied contract claim, they didn't submit it to the Joint Commission, and therefore, as a matter of law under Kansas law, the claims are barred. So the only way they can survive in this case is if they pleaded an express contract that adequately set forth the terms of what that express contract was, how it was breached. And
Counsel, what bothers me, and this is I think piggybacking on what Judge Green was just saying, is that this was at the motion to dismiss stage. And so there's been an allegation in the petition that there's a contract, however vague or conclusory it is. And the defendants have come forward with a contract, and instead of allowing the plaintiffs to kind of look at that contract and then amend their petition in light of that contract, the court has just said, you failed to state a claim. And it feels like that's too early.
Your Honor, at no point did they say we want to amend to assert a breach of the financial responsibility agreement. In fact, their argument was the court should not consider the financial responsibility agreement. I think that you don't see the financial responsibility agreement argument until the last week or the last couple of weeks when the Fifth Circuit, in what I would consider to be an outlier case, deemed that the Baylor contract was ambiguous because of the terms that the term educational services, the Fifth Circuit deemed to be ambiguous. I would submit that we've cited, and the courts are replete with cases all over the country that said the financial responsibility agreement, and they're all very similar across the country, is not ambiguous. Obviously, the Fifth Circuit disagreed with that with that position, I would submit that even if you agreed, and I think I would vigorously disagree with the Fifth Circuit's opinion, but I would say even if you deemed that to be the case here, that is not what was pleaded. That was not what was preserved. If you're going to require a district court to allow an amendment to a petition, you ought to have the plaintiff identify, this is what we are going to amend to state. Here's a copy of it that's attached. And I think in the absence of that, there certainly is no preservation of that issue for appeal.
Council, you're now at 20 minutes, but if you want to take 30 seconds and wrap up. go for it.
Your Honor, I think the district court got it exactly right. She did a wonderful job. She considered the case law in the state of Kansas, the statutes in the state of Kansas, and the obligation of the plaintiff to set forth in their petition and or amended petition what their claim is. And it's even in a notice pleading state, this is too conclusory. You don't identify what the contract is, where the breach of the contract is, and to touch on a question you asked earlier, what the damages are. In fact, what they say what the damages are is a subpar education, which is educational malpractice, which is prohibited under Kansas law. And with that, I thank you for your time.
Thank you, Council. Ms. Walsh, you have 7 minutes.
Thank you. I hope not to take all 7 minutes. I just want to respond to a few of the points. First, regarding the FRA says that it supersedes all prior agreements with respect to matters described. And I would submit that the agreement does not describe what services are or what that includes. Clearly, based on the discussion we're having here, there is ambiguity about what the educational services include. And
Council, could you respond to the opposing counsel's argument about the fact that the financial responsibility agreement wasn't addressed and then there was no request for amendment based on the financial responsibility agreement until it seems like now we're kind of changing courses?
yes, so like I said, as when we filed the complaints, we didn't have that document. What we had were documents pulled from Kansas State's website, including the fee schedule, various representations, what the district court referred to as a rabbit hole of information, representations about what the educational experience will look like, the privileges of being on campus and interacting with faculty. But we didn't have the FRA until the defendants brought it in. And at that point, this kind of goes into the question about amendment. What is a plaintiff supposed to do when we believe that our complaints state a claim for relief and we oppose a dismissal, but at the same time recognize that if the court were to find deficiencies, we would like an opportunity to cure those through amendment. And the rules don't clearly speak to, procedurally how to preserve the opportunity to amend. And in this case, we had requested it in our briefing, we requested it at oral argument before the district court, and the order did not address those requests, which resulted in us filing a motion. To respond to my colleague, there is also nothing in the rules that require a party seeking amendment to, at that time, propose the amended complaint or specify exactly what it will look like, a red line. Some jurisdictions have those rules, but we don't in Kansas. There's no authority for that. But we do believe that we can cure the deficiencies that the court noted. And that it was an abuse of discretion for the court not to have allowed us to do that. I wanted to point to a decision that was issued by another panel of this court just within the last couple of weeks, Danzen versus Harrington. In that case, the court said, and I'm going to quote, "When a plaintiff fails to state a claim, the district court usually should allow the plaintiff to replead within a short period of time. If the repleaded petition still fails, the district court may dismiss with prejudice on the grounds further corrective efforts would be futile. Alternatively, the district court could dismiss the action without prejudice. The plaintiff typically could then file a new case with an improved petition. Dismissal with prejudice may be appropriate only when an insuperable legal bar appears on the face of the pleading, such as a statute of limitations bar." I don't believe we have that here. And the Supreme Court has consistently held that if the facts alleged in a plaintiff's petition and the reasonable inferences arising from them state a claim based on the theory or any possible theory, the court must reverse. And that's from the Williams versus CU out bail bonds case that we cite in our brief. And I think with that, I will sit.
Are there any questions from the panel? Thank you
you.
very much. Thank everyone for their arguments today. The court will take the matter under advisement. This is a fascinating case, and we'll get our opinion out to you as soon as we possibly can.
Thank you, Your Honor.
We'll do have a minute, and then we'll call the second case on this morning's docket.
Yes.
Sounds like there's some kind of drilling going on. Could someone in the back close the door? Thank you. If that's okay with everyone.
It's okay.
All right. Now we'll call the second case on this morning's docket, case number 125084, League of Women's Voters of Kansas et al. Versus Scott Schwab et al. Would the parties please state their names? The appellants.
May it please support Your Honor, David Iriganagarai from Iriganagarai, attorney in Ravenna, appearing on behalf of the appellants as well.
Bradley Schlosser for the defendants.
Thank you. And will Ms. Frost, will you be arguing for the appellants?
Yes, Your Honor.
All right. And would you like any time for rebuttal?
4 minutes, please. Thank you.
All right, 4 minutes are granted, and you may begin.
Good morning, Your Honors. May it please the court. It's my great honor to be here today on behalf of the League of Women Voters of Kansas, Loud Light, Kansas Appleseed, the Topeka Center for Independent Living, and 3 Kansas voters, Mr. Charlie Crabtree and 2 sisters from the Religious Order of St. Joseph of Concordia. As Your Honor requested, I'll just spend a minute talking about the 2 laws that are at issue in this litigation and why the plaintiffs challenge them. The first we refer to as the signature verification requirement, and it now requires that elections officials reject ballots if they decide that the signature on the ballot envelope doesn't match the signature of the voter that is on file on the county registration record. Signature matching certainly has intuitive appeal. The problem is it's extraordinarily hard to do right, and lay people are particularly bad at it. Under this new law, you have none of the conditions that you would want for accurate signature matching, and the officials that are doing it are being told that they are looking for false signatures in the advanced ballot pool despite no evidence over Kansas's 25 years plus of absentee voting that there are false signatures. Ballots identified as non-matches in this pool are virtually certain to be from lawful Kansas voters. The voters most likely to lose their right to vote as a result are older voters, like the members of the League of Women Voters, young voters, like Loud Lights voters, disabled voters, like the ones the center serves, and voters with English as a second language, like those that Kansas Appleseed serves. The second law, we call the ballot collection restriction, makes it a crime for anyone to transmit or deliver more than 10 ballots on behalf of other voters in any one election. I want to be clear, there are certain things about this new law we are not challenging, and I think this is quite important. The same law also made it unlawful for candidates to collect and deliver ballots for anyone but close family members. We don't challenge that. It also required that if you were collecting a ballot on behalf of someone, that you and the voter sign a declaration that they agreed for you to collect their ballot and that you did not exercise any undue influence on them. Again, Kansas has a very long history of ballot collection. Lots of voters have come to rely on it, and there's no evidence of fraud. But we would submit that these other parts of the law, specifically this affidavit, address any concerns about fraud. And at no point has the state explained why 10 ballots is okay, but the 11th ballot is a crime. I'll begin by discussing the threshold jurisdictional issues and then move on to the merits. This court has jurisdiction to hear this appeal. It has jurisdiction under 60-2102A3 because it's an appeal from an order involving the Constitution of the state, and it has a semblance of finality. In fact, the district court said she was deciding everything in front of it. This is like Smith v. Williams, in which this court heard an appeal from a motion for summary judgment, order granting a motion for summary judgment, when there were cross motions for summary judgments on cross claims that were still pending.
Counsel, I've got a question for
Sure.
you. What's left in the district court in these cases?
So right now, nothing.
I seem to remember a prior case.
Yes, Your Honor. Right now, nothing is left because the issue that was left is about another law that relates to false representation of oneself as an elections official, which I know Your Honor is very familiar with. That is actually, the Kansas Supreme Court has agreed to hear that appeal. And so that is currently being briefed. So the district court doesn't have any jurisdiction over it at all. And it could be months, potentially years, we hope not, before it works its way down. But as Your Honor will of course recall, the Court of Appeals decision in that appeal had to do with standing. So it could go up to the Kansas Supreme Court. They could reverse the standing decision. It could effectively bounce back and forth like a ping pong ball. And
I'm familiar with that ping pong.
And all the while,
Nothing substantive left other than in response to whatever the Supreme Court sends back to the district court, if it sends anything back, because the Supreme Court could send it back to our court.
Correct, Your Honor.
First, or whatever.
Correct, Your Honor. And all the while, Kansas voters and the plaintiffs in this case are getting no resolution on these two important issues.
So there are no other claims by any of these plaintiffs remaining to be determined by the district court.
That's correct, Your Honor.
All right, that's what I wanted to make sure of.
Could you, when we're talking about the semblance of finality, and we're thinking about this case, but we're also thinking about the rippling effect that we might have down the line. And so what is the touchstone of that finality? Is it for the current pending claims? Is it for the whole case? Is it, we know it when we see it? What is it?
Always the best standard, Your Honor, correct. I think Kutzit says that it's the finality on the constitutional question. And I think that's what we're dealing with here, is it's this finality on the constitutional question as it relates to these claims. And I think that, you know, the jurisdictional statutes in Kansas are very different than, say, for example, the federal statutes. The federal statutes don't have something like this at all. And I don't think we can ignore the fact that this exists and that it makes a judgment that in a case like frankly, I think this case kind of proves why it's so important. If you have a situation where the plaintiffs were moving quickly trying to protect voters, but by no fault of their own, decisions just kind of got made at the times they got made. And so now you have a piece of it that's up at the Kansas Supreme Court, and then you have the remainder of the case, which is here. And it doesn't make sense to, I mean, particularly when you have a statute that says that you have jurisdiction over orders that finally decide these constitutional issues, to say that we can't reach this decision, which the district court was very clear, was a final decision on the constitutional issues. The district court said, I dismiss all of the claims that are before me.
There's nothing left for that court to do. And you think she made it clear that that's what she was intending?
Yes, Your Honor. I think on page 6 of her order, she does.
Now, my question to you is there was a temporary injunction denied.
Correct, Your Honor.
Doesn't the statute specifically permit such an appeal?
Yes, Your Honor. And that's another ground that I think this court has jurisdiction to hear that appeal under.
That only applies to one case, doesn't it?
Well, that only applies to one issue, correct. However, the motion to dismiss is inextricably intertwined from the decision on the temporary injunction. And I think a lot of the errors that the court made in dismissing both claims kind of fall across the board. Like, for example, the court misapplied the motion to dismiss standard pretty egregiously, not taking our facts as pleaded as true on the merits, for example. Both of those challenges, the ballot collection and the signature verification, include claims based on the Kansas right to vote. We submit that the court also settled on the wrong standard for those kinds of claims. I'm happy to talk about what I think that standard should be. And I think if you look at, we recognize, of course, it's a different right, but if you look at HODES, that provides a really nice roadmap for how you work through this kind of question. The first question, of course, is you look at the text of the Kansas Constitution, and you assume that all of the words there are carefully weighed and in there by design. The Kansas Constitution has an explicit right to vote, unlike the federal Constitution. It's in Article 5, Section 1, and it says affirmatively that voters who are US citizens, Kansas residents, and over 18 shall be qualified to vote. The United States Constitution doesn't have a what we call a guarantee clause like that. Another interesting feature, actually, of Article 5, Section 1 is that, as amended in 1971, it explicitly refers to absentee voting as well. Now, it refers to it in the context of a voter who has either moved out of Kansas, but still wants to vote for the president or vice president, or a voter who's moved within Kansas. And it says that they can vote at their old polling place. And it says in-person or absentee voting. I'd submit, Your Honors, that there's not a whole lot of history as to what was the basis of that change, but that it reflects that Kansas, unlike most states, has an incredibly long history of absentee voting. And in fact, has given absentee voting, the right to absentee vote to all voters for over 25 years now, and has given absentee voting rights to a lot of voters, frankly, for over 100 years. There also is the Bill of Rights, Section 2, all political power is inherent in the people, which is another statement that you don't see in the Bill of Rights in the United States Constitution. And then you look at the next step, which is Kansas precedent. Has the Kansas Supreme Court said anything about these rights before? And it turns out they have. In Moore v. Shanahan in 1971, the Kansas Supreme Court said, since the right of suffrage is fundamental, any alleged restriction or infringement must be carefully and meticulously scrutinized. In 1987, in Farley v. Anglican, which, by the way, was decided 4 years after Anderson, which is where the Anderson verdict test gets its name, the Kansas Supreme Court said again, fundamental rights include voting.
How does that then, but with the reflect upon the district courts and Anderson verdict reliance?
So I think the district court was completely wrong to adopt Anderson verdict. First of all, no Kansas court has ever done it. And I think for very good reasons. One is that it actually is not unlike the undue burden test that was adopted that the court discussed in Hode. in that they're both balancing tests. But what the Kansas Supreme Court says in Hode is that Kansas courts don't like balancing tests. In fact, this is a state where the Kansas Supreme Court tries very hard. It's not that they never do them, but they try very hard to make very clear tests so that litigants and the courts below them know how to apply the law, because balancing tests, right, are trickier. The other thing about Anderson verdict is that it itself is a product of the way that federal courts sit when they are examining state election laws. It involves both the elections clause, which the Kansas Supreme Court in Rivera in June said actually does not restrict the Kansas Supreme Court or these courts from examining voting laws under its own constitutions, right? But that's a little different when you're a federal court sitting in judgment of a state court law. And it also grew out of issues of comity and federalism that just don't apply when a state court is sitting in judgment of its own laws.
And we do allow for some regulation of the voting right? I mean,
Absolutely.
People could set, for example, the time of the polling place might differ from county to county, and we allow for that kind of regulation. So it seems like it's not absolutely strict scrutiny every time. So what is the touchstone? What gets us into strict scrutiny?
So, Your Honor, a couple things. I would submit that the language, to look to the language in Hodes that says the issue with the government's position there was that it came from a governance-based approach as opposed to a rights-based approach. And I think the same touchstone is true with the right to vote. And remember, you don't get too strict scrutiny unless the plaintiffs can show you that it impedes the right to vote. So I think a plaintiff would have difficulty showing you, say, the difference between 8 o'clock or 9 o'clock polling time actually impedes the right to vote. I would submit that's probably a factual question and not necessarily appropriate on a motion to dismiss unless it's completely obvious from its face. But in the same way, I think that the Kansas Constitution explicitly, strongly, admirably protects the right to vote. And so the question that the court should first ask is, does the plaintiff show it impedes on the right? And if so, does the government have a compelling interest? And we would submit that guarding against fraud is a compelling interest. But the next step, does it advance that interest, and is it narrowly tailored to that interest? And here, frankly, this law, the signature matching law, if you really look under the hood, doesn't forward the interest at all, because lay people are so bad at it. The system in which it is set up here is just going to guarantee you that you are invalidating lawful voters' ballots.
Now, let me ask you a question about the signature matching law, because now when you vote in Kansas, you have to sign. And if they don't approve your signature at the polling place, your vote doesn't count. It goes to a counting board and they have to rule upon it. How is that different here?
Well, Your Honor, that law is not an issue in this case.
Right.
I would expect that in practice, you have the person standing before you. I mean, it kind of begs the question of how do you cure a mismatched signature on your ballot, right? If an election official is looking at it and says, oh, I know Judge Hill, but I don't think this is his ballot. And so then how are you going to prove to them it's you? You will probably call them and say, yeah, I voted that ballot, right? Because if the concern is someone else voted that ballot, we don't know, the law doesn't say that. That would seem like a logical way to do it. They might have you come in and sign it again, but then probably you're signing it in front of them, which is what that voter is doing.
And I need to bring this up. There is this regulation that has been published since the time of the district court's decision. What are we to do about that? You have applied for even asking us to issue an injunction. Are we to consider that?
So the regulation is not on the record.
My point.
And you should not consider it, but I will say this on the request for the temporary injunction. When we filed these papers, we didn't know when this court would hear it. And we're extremely grateful that the court expedited it and is hearing us today on this issue. There is still time for this court to reverse the motion to dismiss, send it back down to the district court with instructions to have the Secretary of State file its opposition to our TI promptly, rule on that promptly, and get the signature issue decided before the election. Other states have decided election matters on even faster timeframes. This is a very discrete issue. And I would submit at that point, the regulation does not solve the matter. And I could tell you a lot of reasons why, but it's not in the record and it probably doesn't matter that much to you at the end of the day.
But it's something you can't ignore, or we can't ignore.
It's something that should be a part of the factual.
There are
discussion.
cases out there that say a regulation can moot a lawsuit.
Correct. This regulation does not moot this lawsuit. This regulation reads a lot like the standard that the United States Supreme Court found unconstitutional in Bush v. Gore about the intent of the voter. It provides no safeguards to guarantee that if I'm matching ballots, signatures, and you're matching ballot signatures just a few windows down, we're doing it remotely the same.
I had one other question and then I'll let you get back. And that is, what would your position be if that ballot collection limit was, instead of 10, was 100?
So, Your Honor, I would submit that our position would be the same. And I think one of the reasons is that Kansas did the right thing here, frankly, which is that if it were concerned about fraud, it concocted a way to address it with the voter's own attestation, the collector's own attestation, right there on the ballot. At the end of the day, the numerical limit doesn't advance any state interest.
Do you have a right to collect ballots?
Do you have a right to collect ballots?
I have a right to vote, but do I have a right to collect ballots? In other words, the person who's collecting, what have they lost by this limitation?
So there are two, as Your Honor knows, we have two claims against the ballot collection law. The first is grounded in freedom of expression, and that is the right of the ballot collector. And we submit that this is under, Kansas does look at freedom of expression claims consistent with how the United States Supreme Court looks at this. And at the end of the day, this is exactly like the issues in Meyer and Buckley, where the interaction inherently involves a communication, and it involves a communication that is meant to communicate the power and importance of your engaging in the voting process, and it is understood as that communication.
It's a little different from Meyer, right? Meyer, you've got someone who's going out with a position, advocating for that position. Will you sign this, referendum, et cetera? Like here, you just have, you should vote, fill out this ballot, and I'll make this happen for you. It's a different kind of expressive conduct, isn't it?
So you should vote is a communication. It is absolutely speech. It is what Mr. Crabtree communicates when he is collecting the ballots. It is what the sisters communicate when they're collecting the ballots from their fellow sisters. I would actually submit that, we don't weigh how kind of important the message is to the people who are conveying it, but that in signature petitions, often those folks are hired. In the actual interaction, there isn't necessarily always a lot of whatever. It may just be like, hey, I have this petition, you want to sign it? That is not what's happening with ballot collection here. And actually, by requiring the affidavit, Kansas now guarantees that there's a communication specifically about surrounding voting connected with that.
So your objection is to the limit of 10.
Our objection is limited to 10. Let me give you a very specific example as to why. So one of our plaintiffs is Mr. Charlie Crabtree. Last cycle, he collected 75 ballots. Okay, and voters have come to rely on kind of their neighborhood ballot collectors in this way to help them make sure their ballot gets to where it's going. There's no postal issues. Everyone feels good about it. So now Charlie can go and he can do the first 10. And then all those other voters are waiting for him. He can't go to them. He can go to them. He can say, look, I can't collect your ballot. Then he has to spend a bunch of time that he would spend collecting ballots, having these conversations with those voters, trying to find other people to collect those ballots. So just like in Meyer and Buckley, it does two things. It reduces the number of people who are going to have these conversations artificially, right? Because it says each of you all can only have 10 of them. And then it reduces the quantum of that speech as well, because instead of having those conversations with those voters, Charlie is having those conversations with other people to try and recruit them to do this. Should I talk about standing?
So you are at your 16 minutes.
Okay, well then I'll sit down.
If there are other questions from the panel.
Okay, thank you, Your Honor.
20 minutes.
Thank you, Your Honor. Judge Warner, and may it please the court. There are multiple problems with the plaintiff's case that prevent them from proceeding forward, and why the district court was acted properly in dismissing the case. The most important issue here is the plaintiff's lack of standing. Now, they have organizations are generally not able to bring suit on behalf of themselves unless they have members on whose behalf they are bringing the lawsuit. And only one of the plaintiffs here actually has members, and that's the League of Women Voters. The others take a very broad theory. They call them that they're acting on behalf of constituents. They say that they're acting on behalf of beneficiaries, but they don't meet the tests for standing that have been clearly set forth by the US Supreme Court and adopted by the Kansas Supreme Court. And the League of Women Voters, as I said, is the only, they in their brief, they say, well, you know, all of this is really an academic issue because you can see that the League of Women Voters actually has members. The problem is that the League of Women Voters, in one of the elements of the standing tests, is that a individual member of the association would have to have standing to sue in his or her own right. And the League of Women Voters cannot establish that test. What they have done, the individuals on the signature verification requirement on whose behalf they're trying to act, those members, the individuals for the League of Women Voters who they're actually acting on behalf of are the people, they're not the ones who are at risk in any way with the signature verification requirements.
How do we know
Yeah.
that?
Say again?
How do we know that they're not at risk? How do we know that they're not going to?
Well, it would be, I mean, it's sort of what the court said in Clapper. I mean, it's one speculative component after another. Remember the Kansas statute. I think this is really important. We have in the Kansas statute, number one, that if you are disabled, then you do not have to sign. You can have someone sign on your behalf. So this notion that, well, they may not be able to sign, and that they may have to, their signature, may not be detectable by the election officials. That's already addressed in the Kansas statute in 1124, I believe, 1124C. In addition to that, we have and all you have to do in that case, you can have anyone of your choosing simply sign the ballot on your behalf and say, I'm signing on behalf of Joe Blow, and I have not improperly influenced that individual. And that's all the Kansas statute requires. In addition to that, there are numerous cure mechanisms already encompassed in the statute in 1124B, which has been there since 2012. And remember too that we have, or 2019, remember that an individual who is submitting an advance ballot has already submitted an advance voting ballot application. By the way, I refer to it as advance voting because we have no excuse absentee voting here in Kansas. But so they will have already voted, they will have already submitted their advance voting ballot application in order to get a ballot in the first place. And what's being challenged here is the signatures on the advance ballot. So if an election office.
That's an important, because the claims are limited to advanced voting.
Correct, Your Honor.
It's not the other.
That's exactly correct. So what happens is that if you submit an advanced voting ballot application, there's that cure mechanism. We now have the regulation, which I'm happy to talk about here in a second, but the election officials will have gone through, they will have looked at in our statewide registration system, which here in Kansas, we call ELVIS, the Voting Registration Information System, sort of a cute name. And so what happens is that they will have,
With the acronym.
okay, great. So they will have looked at they will have looked at the application, and if there's any deviation too. So say, for example, that you have someone who maybe it's been 25 or 30 years, maybe their handwriting has changed. Well, now that application is saved in Elvis. So the election officials have that template there. They have the exemplar, and that's the new template. So it's not just the one application that they're the ballot, the initial registration form. So they have that, and all that information is there. The number of mismatched signatures is actually tiny here in the state, but the reality is that the regulation now allows for if it does not have to be absolute precision. It requires, a general matching. Requires that a voter be contacted at least 3 times.
You agree that none of this is in the record.
Here's the problem, Judge. I agree.
I understand, but it was published after the district court made its decision, so it could not be part of our record.
It could not. Well,
what can we consider?
Because I believe that the court has an obligation to consider the law in effect at the time of the decision, and in this case, the law required that the law directed the Secretary of State to adopt regulations to implement the statute. So what the plaintiffs have effectively done, they sued actually pre-enforcement, but right on the eve of right after the statute had taken effect, back in July of 2021. And second, anybody who's worked in government knows, it takes a long time to get a regulation through. It has to go to the Department of Budget, it has to go to the Department of Administration, to the AG, and then back down. It's a very laborious process.
Not an overnight process.
It is, but by no means. And so as a result, what they have effectively done by bringing suit so early and now saying, hey, you can, the regulation was adopted before any elections. So all the voters, for the primary and for the general have had the full opportunity to take advantage of it. But it's sort of now, not to be curt, but it's sort of like, a child who kills their parents and then complains about being an orphan. We have the ability we had to put this in order to put flesh on the bones, in order to guide election officials. There's now training that they have to go through.
The law did go into effect July 1st of 2021.
That is correct. That's correct. And the Secretary of State within months began working on the regulation. it takes a long time. It went up and down. That's the nature of administrative regulations. And in fact, they expedited it and had it go into effect on a temporary emergency basis so that it would be in effect before the primary elections. So, for the voters, there's been no issue at all. That and now every county is contacting per the terms of KR 736-9, contacting individuals if there's any sort of mismatch at least 3 times telephonically via.
Does the existence of the regulation mean that the plaintiffs no longer can challenge the statute on its face?
Well, and thank you for bringing that up. I think it's a good point, Judge Warner, is that remember that this is a facial attack. So your standard, one of the reasons why motions to dismiss are frequently granted in the context of facial attacks is the standard is there can be no reasonable construction of the statute that would justify the legislation. So, what they're arguing is under no circumstances can we have signature verification. Every state in the union has signature verification. The impact of what they're asking for would be revolutionary. And I would simply point out to the court, number one, I thought it was interesting that nowhere in their brief, nowhere obviously in my friend's oral presentation, do they even mention that Kansas is the only state in the country that has a specific constitutional provision adopted at the same time as everything else, including Section 1 that they try to hang their hat on and reference Hodes. But they have in Article 5, Section 4, it specifically directs the legislature to adopt provisions that deal with eligibility of voters who, in order to ensure that only eligible voters are exercising the suffrage. And remember the context of this. The Wyandotte Convention was adopted in 1859. It was designed at that point. You had, we were right on the heels of the Kansas-Nebraska Act, which had overruled effectively the Missouri Compromise. You had all these people from Missouri who were flooding into the state, trying to influence our popular sovereignty elections and establish Kansas as a slavery state. And so voter fraud was explicitly on the mind of the founders in 1859. So that's why, and we cited the Butts case that was referenced by, written by Justice Brewer, who later went on to the US Supreme Court. But in addition to that one, there were also, the Supreme Court has mentioned it, and talked about the need for deference to the legislature on 2 other occasions. In the Lemons v. Noller case, which is 144 Can 813 from 1936, and in the Burke v. State Board of Canvassers, which is at 152 Can 826 from 1940. So the Kansas founders, in the Constitution, we're the only state that has such an explicit provision that directs the legislature to adopt legislation ensuring that only individuals who are eligible to vote can do so. And yeah.
Preparing for today, I came across a 1928 Kansas Supreme Court decision called State versus Beggs. Do you recall this decision? There's I just want to read you a quote from
Sure,
it, and
yeah.
it says that the legislature must not directly or indirectly deny or abridge the constitutional right of the citizen to vote or unnecessarily impede the exercise of that right. What is that standard? It sounds a lot like strict scrutiny.
Well, I would say, Your Honor, that you have to read Section 5, Article 5, Section 4 in the context of that. I'm unaware of any state, and we cite obviously we have the federal standards with Anderson verdict, but we also referenced in our brief, virtually every other state has adopted something similar. We cite to the cases from Tennessee, from Iowa, from Arizona. Minnesota.
This is a Kansas case,
No question.
Kansas statute, Kansas voters. All of that other is interesting, but don't we have to confine our opinion to the Kansas Constitution?
I agree. And that's why I think Article 5, Section 4 is virtually directs you on how to proceed. And remember too, the policy issue here. Election officials need to have deference in order to be able to conduct fair, efficient, effective elections that have public confidence, that ensure the legitimacy of the election. If we, as the plaintiffs are advocating here, get rid of signature verification, they're saying, oh, gee, it's so inherently unreliable. It's so inherently unreliable that we've had virtually no signature mismatches, and individuals rejected. And they, in their allegations in the petition, what they say is it's like, well, at some point in the past, you had a couple of individuals who didn't get enough time to, go ahead.
You say that there have been virtually no signature mismatches. Have there been
Rejected votes is what I meant. Thank you for that clarification.
And
Yes.
So there have been virtually no rejected votes. And of the votes that were rejected, do we know how many of those were legitimate voters?
There's nothing in the record on that
Is
point.
that
But
because you're here on a motion to dismiss?
there is, but Your Honor, I guess what I would say in that point is that when we're looking at election type of legislation and regulations, you need to look at the electorate as a whole. The fact that there's always going to be individual circumstances with, an individual voter who may have had an issue, and those can be dealt with on an as applied basis. But to bring a facial challenge where you're invalidating the entire regulatory regime, then throws the whole system into chaos and undermines public confidence in the integrity of the election system.
Council, I don't know how much time you have left.
6.5 minutes.
Okay, I wanted to talk to you a little bit about the ballot collection.
Sure. Thank you, Your Honor.
People go around, collect ballots, take them in. Now they have to sign an affidavit. The voter signs an affidavit
Yes.
and the collector signs an affidavit, but they're limited to 10.
Yes,
Is that basically correct?
that's correct.
How's that different? The only thing that I see different than mail-in ballots is you don't have an affidavit.
Well, on the ballot collection restrictions, all what they're trying to do is to minimize the amount of undue influence that is placed on certain members of the community. Often, people go into nursing homes, for example, and will sort of ballot harvest as many as they possibly can. The burden, to the extent there is one, and by the way, this is in terms of I would say just as a legal threshold, first of all, they brought a freedom of association claim. There is no case of which we are aware, none, where they have held that the collection and return of those ballots implicates any free speech rights. So different, put aside that, they all talk about, well, we are encouraging people to vote and we're we want to send applications to individuals. The weight of authority says that that's not either, but on the collection and return, I'm not aware of any cases where they've had maybe there's some outlier somewhere, but there is where they've said that implicates speech rights. And in terms of the right to vote, by the way, I mean, it's not the people who would be collecting whose right to vote is at issue. It would be the individuals who would be voting. So I'm not sure how they have standing to bring that claim. But let me go to the merits, which is what you asked about. So the concern that the legislature had was in ensuring that there was not undue influence. We've seen, over and over around the United States, and it's been talked about where there have been problems with individuals engaging in improper influence in the context of ballot harvesting. So in terms of what the burden would be on those voters, I mean, we've had, and I acknowledge that we're, here in Kansas state court, but the US Supreme Court said in the Crawford decision that just having to go, for example, to the DMV in order to get your voter ID is not so great a burden. It's just part of the vagaries of life that it would impede an individual's constitutional right to vote. So how is it that having to put a stamp on a absentee ballot and send it in, or go over to the mailbox, or we've now in the Brnovich case, which we cited in our brief, which admittedly was a Voting Rights Act case, although in the Ninth Circuit where that case had come up, there was also a constitutional claim which had been rejected. The Ninth Circuit even shot it down. They later granted en banc and didn't even talk about the constitutional claims. So those have been dismissed at all times as they were on remand. But the reality is that when you have a claim, a ballot collection restriction, all the voter has to do is, we in Arizona, there were zero. The restriction said that you couldn't have anyone else other than the voter himself or herself collect and return the ballot. Here we're allowing 10 because we wanted to at least allow family members to be able to do it. It's designed, they're saying, well, gee, it's the 11th that it's 10 and could make the same argument. And I think you did. It's like, well, what was the difference if it was 100? Then they'd still be complaining. They want to have no collection allowed whatsoever. And that is, as far as I can tell, again, goes against obviously the Supreme Court authority, but virtually every other state as well. And so, I think that there needs to be a great deal of deference.
The fact that Kansas has this rich history of respecting voting rights, does that change the landscape for us?
I would respectfully disagree, Your Honor, that I think what Kansas has the rich history of is Article 5, Section 4. Our history is founded on bleeding Kansas and what happened in the state sovereignty elections. I think I think they've misrepresented significantly the history of our state. We have always had deference to election officials and being able to conduct fair, effective, efficient, and free elections that allow legitimacy in the minds of the public. And I think that this is, and again, I say this with all respect, but this is, I think the court would be greatly overstepping its ground. This is a matter of deference and respect for coordinate branches. We don't want the courts to be acting as supra-election administrators. And what they're essentially asking for by advocating for the strict scrutiny standard is to say, look, we're going to have on each and every one of these regulations, we're going to now be going to the court and saying, we want you to micromanage. What do you think? Is that training? Is that signature verification fair?
Article 5, Section 1 pretty well preserves the primacy of the vote.
But it has to be read in the
And so
context.
why wouldn't it be, it seems to me pretty close to being strict scrutiny.
I would just respectfully but strongly disagree, Your Honor. It has to be read in the context of what occurs 3 sections later. I mean, it is sure individuals have the right to vote, and maybe, and if you are categorically taking away the right to vote and saying, I mean, if it was something along the lines of, hey, we're going to impose a restriction on, that you have to be, if the legislature tried to do something, I don't, where it was an automatic restriction. I mean, something about you have to be in the state. This is simply a regulation or statute designed to ensure that the people who are voting are actually eligible to vote. That's all it's doing.
Are you asking us to adopt Anderson verdict?
I think, yes. I mean, we're asking you to adopt a standard that has the appropriate degree of deference to the legislature and to election officials. I think a strict scrutiny standard would not only be really, I mean, you'd be on one of the first states in the country that really just, again, with respect, doesn't make sense in the context of Article 5, Section 4.
HODUS? We should disregard HODUS?
HODUS, Your Honor, dealt with a case involving a Section 1. It was dealing with the inviolate rights and personal integrity, bodily integrity in the context of abortion. That is, the case said nothing about voting. And what they've tried to do here is to graft onto that and saying, well, now every single time that there is any kind of fundamental right now, no matter what it is, it has to be considered in the context of strict scrutiny. I think that the court in Rivera even pushed back on that.
Counsel, what about, if not HODUS, how about 50 years, at least back as far as 1971, and maybe back as far as 1928, where we say that it's a fundamental right in Kansas, and that you must not directly or indirectly deny or abridge that right or unnecessarily impede the exercise of it.
Even if it is a fundamental right, Your Honor, there has to be deference towards the election officials in order to conduct elections, for the same reasons that the Supreme Court adopted the Anderson verdict standard, and the same thing that they said in Monroe v. Socialist Workers. Any kind of election regulation, as I believe you acknowledged at the outset, is going to have some sort of impact on voting. If we subject this to strict scrutiny and then narrow tailing, you're hamstringing the legislature, you're tying the hands of election officials, and you're going to be creating a significantly higher burden on the ability to conduct our elections in this state. And I think that would be not only revolutionary, but incredibly counterproductive. I don't think the law can possibly be interpreted that way. And I would suggest that any cases where they're using that right, I mean, are focusing on a much different scenario. And no one is suggesting that the legislature could somehow categorically take away a right to vote in a particular context and have that just be subject to deference. But the kind of election mechanics that what we're dealing with right here is where we really need deference to the legislature to the most significant degree.
Counsel, at this point, I think that you're out of time, but I want to make sure that my colleagues have asked all the questions. All right.
Thank you, Your Honor.
Thank you very much. With that, you have 4 minutes.
Thank you. I'll try and be quick. Standing, the question before the court is there even one plaintiff that has sufficiently alleged facts at the motion to dismiss stage to show they are at substantial risk of injury from the signature matching requirement? The League of Women Voters has members all across the state. Most of them are older, as pled in the complaint. The case Self-Advocacy Solutions v. Jager found that a disabled voter with a heightened risk of their ballot being rejected under signature matching had standing at this stage. And I submit the same is true of Kansas National Education Association v. State 305 Kansas 739, which was a case brought by a teachers association, and the court found they had standing to challenge a law that hadn't yet impacted any individual teacher. Even the federal courts don't require that you name an individual member at this stage when the law has yet to impact the members. Resource diversion theory also standing, and injuries to the constituencies that they serve. My colleague ignores that federal courts routinely find standing on these types of grounds for these similar organizations. So I submit at least one plaintiff has has alleged sufficient facts that taken in their favor show that they're standing.
Could you respond to your colleague's argument about the fact that this is a facial challenge and thus it's just, is there any reasonable or legitimate way that this can be construed?
Yes, Your Honor, a couple statements on that. Even in a facial challenge in a situation like this, courts generally consider the facts about the burdens. In Anderson Burdick, in facial challenges, they consider the facts about the burdens. One of the weird things that the district court did here is claim to adopt an Anderson Burdick test and then applied it in a way that federal courts don't apply it. They generally, often district courts are reversed for granting motions to dismiss on facial challenges under Anderson Burdick if they do it before discovery and they don't weigh the burden. So that's thing number one. Thing number two is that even in a facial challenge, the court is not supposed to come up with hypothetical instances in which the law might be valid. In this case, those hypothetical instances would be when a signature matcher actually catches fraud using a tool they are not equipped to do in a pool of ballots that probably doesn't have any fraud. I would submit that in most of those cases, if they do catch the fraud, it will be because of one of the other dozens of safeguards that Kansas provides and has kept voting safe and secure in Kansas for decades.
Thank you.
This is not the only state, or sorry, not all states have signature matching. That's just not true. This isn't the only state with a provision in the Constitution that says the legislature can make laws protecting the ballot. I would submit that Your Honor, Judge Hill gets it exactly right, that you would read out section 1 to give that reading to the Constitution. With the regulation, I would just ask that the court compare it to the declaration of Dr. Muhammad found at volume 3 to 11 of the record. You can see all kinds of ways that the regulation doesn't solve the matter, but the right to vote is at stake. The Secretary of State doesn't say how much training, what it would look like, how to decide what a match is. There's no guarantee the voter gets guidance. And we know, as we alleged in our complaint, that gets notice. And we know, as we alleged in our complaint, that voters do not always get notice. On the no case has ever found ballot collection to be protected. The courts are actually divided on this. I would draw your attention to Priorities v. Nessel, which address the collection of absentee ballot applications. They simply are not that different. And the case that we submitted to Your Honors in our supplemental filing on August 17th, the Montana Supreme Court is looking at exactly this issue the Montana court's looking at this issue exactly right now under the Montana Constitution. That court denied a motion to dismiss a freedom of speech claim based on ballot collection as well. And again, I think it goes back to first principles of the First Amendment. You ask, are they communicating a message? Will that message be understood? In this case, I think that the record, as the facts as alleged, at least make that something that we should be able to prove. And I would submit that, in fact, because of the affidavit, they absolutely are. Thank you, Your Honors. I appreciate your time.
Thank you. I want to thank both counsel for your arguments today and your arguments in the briefs. This case is now deemed submitted, and we will endeavor to render a decision as soon as we can. Our court is now stands in recess until this afternoon.